Director General of the Department of Home Affairs, Mr. Tommy Makode, the Commissioner of Border Management Authority, Dr. Mike Masia Pato, Senior Management of the Department of Home Affairs, Acting DG of Immigration, Ndate Mujiru Matthews, and Chief Director for Refugee Protection, Ndate Mandla Madumisa, media houses, and all guests present today. On the 10th of November 2023, the Department of Home Affairs published in the Government Gazette number 49690 the white paper on citizenship, immigration and refugee protection towards a complete overhaul of the migration system in South Africa for public comments. The date for submission of comments was extended to the 31st of January 2024 by way of a notice published in the Government Gazette, notice number 4240 of the 8th of January 2024. The responses have been overwhelming. Individuals, that is citizens, asylum seekers and refugees, as well as public interest groups, companies, national and local government departments, premiers, research institutes, political parties, International Commission of Jurists, United Nations High Commissioner for Refugees, UNHCR, International Office for Migration, IMO, United Nations Children Fund, UNICEF, and many others made their voices heard and made constructive comments. The Department of Home Affairs team and I conducted public hearings in all 9 provinces. I also conducted several radio and television interviews on the white paper with participation by members of the public. The outcome of the engagements and public comments is that the policy position adopted in the white paper enjoy wide support. Only a handful of public interest groups are opposed to selected policy positions, such as the withdrawal of 1951 Refugee Convention, the 1967 Protocol, and re-acceding to them with reservations, proposed repeal of Section 4.3 of the South African Citizenship Act, and the first safe country principle. These are the things that people objected to. The Department of Home Affairs carefully and duly considered all the oral and written submissions. This final white paper is a product of the set robust engagements. The Cabinet of the Republic of South Africa approved this final white paper on Wednesday, the 10th April 2024, exactly a week ago, and has been published in the Government Gazette number 50570 on 17 April 2024. That is today. We will attach a copy of the Government Gazette for your reference. Let me come to the issue of migration. Conflicts, armed violence, disasters, pandemics, climate change, seeking better business and work opportunities, and other factors force people to leave their countries of origin to other countries. Public comments on the white paper reaffirmed the urgent need to adopt effective policy measures and legislative interventions dealing with migration in South Africa. South Africa has different pieces of legislation dealing with citizenship, migration, and refugee protection, namely the Citizenship Act passed in 1995, the Immigration Act passed in 2002, and the Refugee Act passed in 1998. In fact, South Africa's Citizenship Act is a relic of the colonial era and a replica of the 1949 Citizenship Act under the Union of South Africa. There are people who seem to take offense when we refer to this fact, that we actually hate the fact that our Citizenship Act, passed in 1995 after democracy, resembles that which was passed by 1949 by the British government when South Africa was a union. And if anybody wants clarity on that issue, I'm ready to give that clarity. In practice, this piece of legislation are not in harmony with each other. Piecemeal amendments were made without any policy framework whatsoever. Now let me come to refugee protection. The United Nations adopted the 1951 United Nations Refugee Convention and the 1967 Protocol relating to the status of refugees. Meanwhile, the Organization of African Unity, which is now called the AU, African Union, endorsed its own 1969 OAU Convention covering the specific aspects of refugee problems in Africa. This was done in 1969. So it's referred to the 1969 OAU Convention in order to deal with peculiar circumstances of migration refugees in Africa. This was done in the spirit of Pan Africanism. In 1969, the 1969 OAU Convention prohibited refusal of entry, expulsion of extradition of asylum seekers and refugees, and also provide for certain exclusion on certain grounds. In fact, the refugee laws in most AU countries, based on the 1969 Convention, are much more stringent than the Refugee Act in South Africa. And by the way, we want to emphasize that the principle of Pan-Africanism does not promote illegality or illegal entry in the countries that are signatories to the 1969 OAU Convention. I would like to deal with the issue of asylum during the apartheid era. Asylum seekers and refugees were not recognized in South Africa until 1993. During the apartheid regime, South Africa did not accede to any international and regional conventions related to the status of refugees and asylum seekers. You will know that because of apartheid, South Africa was banned from many international fora. South Africa administered its refugee policy on an ad hoc basis, granting refugee status mostly to white nationals from Zimbabwe, Portugal, and Mozambique. The Aliens Control Act governed immigration during that era of apartheid. The preference of whites over non-whites or blacks became the focus of their immigration policy. That's why we couldn't live with it. Now, asylum during the democratic era. The Refugee Act was passed in 1998 in line with the 1951 Convention, because at that time now, South Africa was now accepted internationally because it was now a democracy. The Refugee Act prohibited refusal of entry, expulsion or extradition of asylum seekers and refugees. Let me deal with the issue of accession to international agreements. In 1996, 2 years after the first democratic elections, South Africa acceded to various international agreements, such as the 1951 Convention, the 1969 Protocol, and the 1969 OAU Convention, and other international instruments. This was done without the government having developed a clear policy on migration, including refugee protection. The government did not make reservations and exceptions permitted in terms of international law. Both the 1951 Convention and 1961 Protocol provides for reservations. In other words, the United Nations itself knew that the protocols and conventions certain areas might give problems to countries. For instance, the 1951 convention has got 46 articles, and the UN was worried, what if one country, out of the 46 articles, they find one article which they can't live with? Not because they hate it, simply because it's impossible for them to accede to it because of their capacity or their capability or their the level of economic development. What do? Do they then say, no, this convention, this whole convention is not ours, we are not acceding to it? Now, the United Nations was worried about that. For that reason, out of the 46 articles, they put Article 42, whereby they say any state can make reservations to articles of the convention, but they put articles on which they don't allow any reservations. That is Article 1, 3, 4, 16, 3, 33, and 34 up to 36. These articles deal with things like definition, discrimination, access to courts, etc., etc. But they say the rest of the articles, if a country feels like they can't be able to achieve a particular, implement a particular article, they've got the right to do reservations. And many countries took advantage of this Article 42 of the United Nations Convention and made reservations. South Africa did not make any reservations in respect of both the convention and the protocol. And we believe this must be corrected, because in our understanding, when you don't make any reservations, you are telling the world that anything that is asked for us in the convention will be able to give. Anything that is requested from the country will be in a position to provide. Anything that is demanded from the country in terms of the convention, the country will provide. And we know there's no such a country in the world. And that's why we believe this part of acceding without reservations needs to be corrected. Now, what is our policy framework and recommendations? The white paper proposes that the government of the Republic of South Africa must review and or withdraw from the 1951 Convention and the 1967 Protocol with a view to accede to them with reservations, like many other countries did. All what the South African government intends achieving is to exercise its right granted in Article 42 of the 1951 Convention and Article 7 of the 1967 Protocol, and make reservations accordingly. The refugee protection and immigration legislation must provide for reservations and exceptions as contained in the 1951 Convention and 1961 OAU Convention, particularly in that South Africa does not have the resources to grant all the socio-economic rights envisaged in the 1951 Convention. Remember, these rights were developed for all the countries, rich and poor, and there will be those countries which won't find it a problem, but others will. Let me come to citizenship. The genesis of the 1961 Citizenship Act is Citizenship Act 1995 and other laws. The current citizenship legislation, which is now presently in use in South Africa, has its root in the 1949 Citizenship Act and other relevant successive laws governing citizenship. The 1949 Act and other relevant laws were not only discriminatory on the basis of race, sex, but the native, as black people were referred to, were totally excluded from South African citizenship regime. The South African Citizenship Act provides for three main forms of citizenship, namely citizenship by birth, citizenship by descent, and citizenship by naturalization. Now, what is our policy proposal on citizenship? The white paper must make radical proposals regarding citizenship. Section 4.3 of the Citizenship Act required to be reviewed together with other sections, including those relating to citizenship by naturalization, during the legislative process. If you check the 1949 Act, on which our 1995 Act is based, it talks about people of a sound mind. And you are aware that in a democracy, we can't live with that. So we need to make radical changes. The United States of America, Canada, Switzerland, and Britain are developed countries with resources that far exceed those of South Africa, and yet they've developed strict immigration, citizenship, and refugee laws in order to protect the right of their citizens. The Citizenship Act and the Birth and Death Registration Act must be repealed in their entirety and be included in the single legislation dealing with citizenship, immigration, refugee protection. This will remove contradictions and loopholes in the path towards citizenship, as is now the case with the three pieces of legislation. The criteria for granting any forms of citizenship must be strictly in accordance with the law. A proper register should be kept for all persons granted citizenship by naturalization. The register must be tabled every year in Parliament by the minister. Let me come to immigration. Before the Immigration Act 13 of 2002 was enacted, the applicable legislation was the Aliens Control Act and the Aliens Control Amendment Act. Now, when it comes to the issue of illegal foreigners, South Africa is today a great place to live in, and many people in the world aspire to live, work, or be the citizens of South Africa. In the results, many foreign nationals come to South Africa and stay in the country illegally, unfortunately illegally. No one can account for undocumented migrants, something which sometimes the media find difficult to understand, but we believe it's simple to understand, because a person who has entered illegally in your country and do not go to announce themselves to authorities as provided for will remain unknown to authorities until that person is met by immigration officers or law enforcement people. The Department of Home Affairs has no idea as to how many illegal immigrants are in South Africa. However, immigration services deport between 15,000 and 20,000 illegal foreigners every year, and at a huge cost. The number is on the increase, obviously. The establishment of the Border Management Authority, or BMA, should significantly reduce the risk of illegal foreigners entering the country illegally. And Dr. Masia Pato, the commissioner, has on Sunday released some figures to show the work that the Border Management Authority has done over a period of a year. The Immigration Act introduced fundamental change, albeit controversial, and a host of visas such as the temporary visa, study visa, business visa, critical skills visa, corporate visa, spousal visa, retirement visa, relative visa, intra-company visa, and permanent residence visa. Ladies and gentlemen, we believe this must be reviewed, because we can't be having so many visas. It is an administrative backlog. I mean, a nightmare. It's an administrative nightmare to be able to administer so many visas. So there's a need to review the current visas under the Immigration Act. Visas such as the relatives visa, corporate visa, intra-company visa might have to be abolished. The simple reason being that they are just a repetition. I mean, what's the difference between corporate, intra-company, business? They're supposed to be the same visa. They are one business. Why were they divided into so many subsections? That causes administrative nightmare. So the white paper is proposing that that needs to change. Additional limited duration permanent residence visas linked to minimum investments will be introduced an e-visa for tourists and remote work visas, as you have heard. The introduction of limited duration permanent residence visa with minimum investments will add impetus to economic stimulus. The introduction of limited duration permanent residence visas will curtail the current difficulties in which individuals, business, and even church organizations and others resort to fraudulent means to acquire permanent residence status. Some of the proposed changes are already being implemented, ladies and gentlemen, as you know, as part of the Vulindlela Project's recommendations. Last week I stood here in front of you to tell you about the recommendations of Vulindlela. So what the white paper is proposing, some of it is already happening. The maximum period to issue visas will be shortened. The new bodies to issue visas will have to strictly observe the new requirements. Transitional mechanisms will be built in the new legislation to fast-track the resolution of current backlogs. Let me come to policy proposals now on immigration. So the white paper proposes that border control must be coupled with immigration. That Border Management Authority Act must be reviewed to align it with immigration and citizenship new policy framework. You might actually be curious to ask, why are we, the Border Management Authority, still a new baby? Why are you already making proposal about the amendment of his act? Is because, as we said, all these acts, citizenship, asylum, refugee protection, immigration, are sort of a continuum, and border management is part of that, and we believe they should not be separate, because when they are separate, they sometimes conflict with each other. The policy framework must provide for the establishment of the advisory board, which comprises representatives of the Department of Trade, Industry and Competition, Labor and Employment, Tourism, South African Police Services, South African Revenue Services, Education, International Relations and Cooperation, Defense and Military Veterans, Health, and also the Director General of the Department of Home Affairs. The board must also comprise representatives of organized labor, including 4 individuals on the grounds of expertise in administration, regulatory matters, or immigration law, control and adjudication and enforcement, which must be appointed by the minister. The current minister has published the new critical skills list in August 2022. The list has been trimmed down in respect of occupations and professions. The critical skills list is necessary to attract foreign skills required for the development of South Africa. The list was compiled in consultation with all relevant stakeholders, including NETLEC. Policy and legislative interventions are required to tighten the procedures and strengthening monitoring capacity by introducing integrated IT systems capable of flagging fraudulent activities in the issuing of visas, identity documents, marriage certificates, and passport. This includes giving wide statutory powers to existing anti-corruption unit within the Department of Home Affairs. The new policy must provide that members of the anti-corruption should be seconded from the South African Police Service. The relationship being that members of SAPS enjoy wide statutory powers, including search, arrest without warrant at times. Now, legislation must be introduced to strengthen the powers of immigration officers and inspectorate and make continuing training compulsory. The majority of members of the inspectorate must have legal qualifications and policing experience. The recent publication of the National Labour Migration Policy introducing quotas for employment of foreign nationals will go a long way in diffusing simmering tensions between South African citizens and foreign nationals. When the Immigration Act was enacted, provision was made for the establishment of immigration courts. However, the Immigration Act was amended in 2004 to remove the establishment of such courts. Now, the Immigration Division and Immigration Appeal Division. New policy framework and legislation intervention is required to establish the Immigration Division, whose members are duly qualified to deal with granting of various visas. The current system is unworkable and staff members are overworked. Appeals reviews are dealt with by the DG and the Minister. Given the responsibilities that we have, it is impossible for them to deal with the appeals or the reviews. Given the current challenges, there is merit in stabilizing an independent body to deal with appeals or reviews, such as Immigration and Refugees Board, Immigration Division, Refugee Protection Division, and Immigration Appeal Division. We want to refer to some of the countries, like Canada, where the Immigration and Refugee Protection Act of 2001 in Canada makes provision for Immigration Refugee Board, consisting of Refugee Protection Division, Refugee Appeals Division, Immigration Division, and Immigration Appeal Division, and Special Immigration Appeals Commission. The Canadian equivalent of Refugee Status Determination Officer is the Refugee Protection Division. And maybe I need to explain. When somebody comes into South Africa demanding refugee status or wishing for asylum status and eventually becomes a refugee, they visit one of the 5 refugee reception centers. And there, the person who listens to their story is called an RSDO, or Refugee Status Determination Officer. Now, we found that in advanced countries, they've got Refugee Protection Division. This is a statutory body charged with responsibility of taking decisions on asylum applications. In order to avoid backlogs, its members are appointed on a full-time basis in terms of the Canadian Public Service Act. In other words, like the Refugee Protection Division, they perform functions that are assigned to the RSDOs in South Africa in terms of the Refugee Act. And the RDP conducts proper hearings with asylum seekers being afforded the right to legal representation. This will obviate the long-winded and tedious appeal process under the current legislative framework in South Africa, because every case, or almost every single case, adjudicated and finalized by a Refugee Status Determination Officer in South Africa, is going on appeal. Nobody accepts the final determination by the Refugee Status Determination Officer. There's always an appeal, which is an ending, and that develops backlogs. A party that is aggrieved by the decision of the Refugee Protection Division in countries where they use that system must appeal to the Refugee Appeal Division, with majority members being appointed for full-time on the basis on a full-time basis, and 10% of whom must be members of the bar or attorney for at least a period of 5 years. So these are highly legally trained people, which is not the case in our case, in the case of South Africa. Furthermore, the Canadian legislation clearly makes a distinction between economic immigrants and refugees. The same approach is adopted in the white paper. We are adopting the approach that there must be a special dispensation for economic migrants, We can't keep on pretending that they are refugees when they are not. In the United Kingdom, adjudicators equivalent to refugee status determination officers in South Africa, must be members of the bar or attorneys for a period of 7 years. The strict qualification requirement in Canada and UK are because asylum matters are by their nature very complex and involve international refugee law. If you don't believe me, just read the various judgments which you refer it in the white paper. You'll see that even judges among themselves differ on how to interpret international refugee law. Now, further policy framework proposal on refugee. The new policy framework and legislative measure must include the establishment of structures such as we have in these other countries like Canada. The decision-making powers will be quick and virtual hearings can be introduced at the points of entry, as in countries like the Netherlands. Consideration will be given and provided for in the new integrated legislation to appoint either serving judges or retired judges or senior counsel as chairpersons of the appeal bodies that I've referred to. That is our proposal in the white paper. We want the very highly qualified people like retired judges to sit and make these decisions, because as I've said, decisions made by people who are regarded as junior are always subjected to appeals. In instances of unlawful entry into the Republic, an additional requirement must be introduced that must show good cause for their unlawful entry or presence. The minister should be empowered to declare an asylum claim made by an asylum seeker who has a connection to a first safe country invalid. In other words, the first safe country principle must be strictly applied. This will include a person who may apply to be recognized as a refugee in that state. I think I need to explain this a little bit because it has raised controversy even at the international level, because countries have been asking, if you are running away from a country which is recognized by United Nations High Commissioner for Refugee as a country that is in trouble which can generate refugees, if you enter the first safe country, in other words, the first country where the issues that made you run for your country are not there, like as you know, the convention speaks about war, it speaks about natural disasters, it speaks about prosecution on the basis of your political activities, your religious practices, your traditional beliefs, and even your gender, your sex, as in LGBTQW. There are countries which prosecute those. Now the question is, if you run into a country which does not have those, why do we pass? If I may ask it directly, because it was asked in Parliament, why do people pass so many safe countries to specifically come to South Africa? Why can't it be a policy that once you pass through a safe country, that's where you must apply for asylum? Members of the media will remember, because some of you also asked the questions on our behalf, of the Afghan citizens who came via base breach, and the matter even went to court. They first went to Pakistan, they left and went to Qatar, they left and went to Zimbabwe, then they left and went to Zambia, but it's only in South Africa where they are applying for asylum. And the question is, all the other countries that they went through, Pakistan, Qatar, Zambia, Zimbabwe, do not have all these things which they may have run away from the Taliban. Why specifically South Africa? And countries are asking these questions because it burdens one country when there are so many which can share the burden. So we are proposing the white paper that this principle of first safe country must be looked at seriously and be applied, or at least us in South Africa, we want to legislate on it. This policy framework will discourage asylum seekers who deliberately fail to apply for asylum in the first safe country, as I've already said. Exemptions and economic migrants. Given the challenges of economic migrants, the exemption should be retained, and the minister must exercise such powers in exceptional cases. Agri South Africa, in its comments on the white paper, agrees with the policy options, but proposes that the special exemptions should be granted in the agricultural sector, which has for years also relied on unskilled foreign labor. The Department of Home Affairs is ready and willing to enter into public-private partnerships with such organizations as Agri South Africa to tackle the issue of economic migrants by agreeing on quotas as proposed in the labor migration policy submitted by the Department of Labor and Employment to the Department of Home Affairs and to NETLEC. The provision for special exemptions will cater for economic migrants and reduce the number of economic migrants who come posing as asylum seekers and refugees. Furthermore, it will address the burning issue of employers resorting to hiring illegal migrants. I want to come to the contagious issue of informal shops, what are colloquially referred to as spaza shops. The spaza shops owned by foreign nationals require effective regulation. In a workshop held in October 2023 and attended by the House of Traditional Leaders, District and Metro Mayors, South African Local Government Association, SALGA, and relevant government departments. In this case, it was housing, small business, COGTA, and Department of Trade, Industry and Competition. They all attended this workshop at the ministerial level, except Trade and Industry and Competition, which sent the Director General, which we believe is senior enough. Firm resolutions were adopted in this workshop to conduct an audit of all spaza shops in the country by municipalities. This is with a view to have all spaza shops registered and establish the immigration status of the owners. Furthermore, municipalities will have to introduce bylaws to regulate the location and other requirements such as health and safety. Ladies and gentlemen, you have heard about many stories of children eating food from spaza shops, either dying or getting sick, and people not being able to understand what's happening, and it results in some people wishing to chase away foreign nationals. We believe this thing must be regulated. So when we say municipalities must introduce bylaws, we're just talking. The Minister of COGTA has already developed draft bylaws as agreed in the workshop in October. I have seen the copy of those bylaws. We have sat together as a department and made inputs to the bylaws because we want them to be in line with the present Immigration Act. Traditional leaders will play an important role in respect of informal shops located in their communal land because they are also complained a lot and they attended that workshop. So we're not going to have a spaza shop that is hanging, if I may explain this area again. We want them audited. We want the owners to come forward and the spaza shop be registered. And when you register, we want documentation. If you don't have documentation, we'll obviously have the spaza shop closed. That is the proposal we made to the minister to put in that series of bylaws. If, on the other hand, you have got the right to be in South Africa, all that is left is for you to register. And after registration, you will have to register with South African Revenue Services and start paying tax on that spaza shop. If you are in the bracket of tax paying, that will be determined by SARS and not us. Then, as I said, the Department of Health will have to make standards and say, we are giving you this registration and these are the conditions. Some of the conditions which will demand, on which we have made an input, is that you cannot sell food in this bazaar shop and sleep there and cook there and eat there and wash inside there and hold prayer or Sunday services in there. That will have to be abolished. And that's the proposal that we are making in the white paper. But as I said, we have already made these inputs to the Minister of Culture, and we are aware that she said after our input, she will send it to other stakeholders like municipalities to put their input before that act that is passed as policy. Conclusion, I take this opportunity to thank all the concerned citizens and staff of the Department of Home Affairs who worked tirelessly in developing this policy framework contained in the final white paper. The constructive comments and criticisms played a significant role in shaping this final white paper. An explanatory memorandum will accompany the distribution of the white paper to the public at large, and we are going to annex it to this speech. A complementary and integrated bill based on this final white paper will be introduced in Parliament without any further delay. You are aware that the white paper is just a policy, and acts of Parliament must be based on this. So very soon, a bill will have to be introduced in Parliament to bring this white paper into operation. Thank you very much.
Thanks, Minister. We will now open the floor for questions. Please identify yourself and the media house which you represent.
Sorry, I can't do that.
Yes, you can.
Technology.
Minister, I know you're not a Sangoma, but I'd like to find out what are the prospects of your litigation, especially with the Helen Suzman Foundation at the Supreme Court of Appeal, especially because this white paper has not yet been finalized using the current legislation. And also you mentioned that
What do you mean white paper is not finalized?
Oh, I mean it's not an actual law at the moment. You know, it still has to go through Parliament and the NCOP and everything.
No. Before you go on, this is the final white paper, because the cabinet passed it last week. It's final, meaning it's final policy. It's policy of the country now, because cabinet has passed it. What will then happen? Yes. No, I'm sorry to cut you short, because I don't want you to continue with the question on the basis of wrong information. This is a final white paper. That's why I kept on saying final, because it has been passed by a cabinet after public comments. What is still going to Parliament is that a white paper or a policy document is not how do I put it? It's not legislation. It's a policy. You still have to develop a law based on that policy. Look at the Marriage Act, which is now in front of Parliament. If you remember, we started with the green paper, then the white paper, and we debated, then we put the bill. It is now a bill in Parliament. We are going to do the same here, because the white paper said the Citizenship Act, the Refugee Protection Act, the Immigration Act, there ought to be one omnibus legislation with different chapters, and that will be in the bill. And if Parliament passes it, then it becomes a law. But this white paper is now policy of the country, as from the 10th. Not the 10th. On the 10th, the cabinet passed it. As from today, because it's now gazetted officially. It has just been gazetted today. If you go to the government gazette, you'll find it. So it's policy of the country. Thank you. No, then you can go on with your question.